Can registered designs be more powerful than patents?
In any single registered design, less is more. The less you show, the wider the scope of protection you've got.
What are registered designs and what are they for?
It doesn't matter how it works or even if it does anything, it's just about what it looks like.
A colonoscopy device, you're kidding.
File as soon as possible. You never know what your competitors are going to do next week.
Hello and welcome. I'm Robert Games, Managing Director of Albright IP. Welcome to our podcast, Figure 1, an IP discussion. Today I'm joined by Freddie Noble, who heads our office in Cornwall, to discuss the importance of registered designs in the IP landscape. I'll be asking the somewhat controversial question, can registered designs be more powerful than patents? Freddie, thank you for joining me.
You're welcome.
So, Freddie, tell us, what are registered designs and what are they for?
So registered designs, they protect what a product looks like. So whereas patents, which I think a lot of people have heard about, protect how something works, the sort of technical features, a new invention, a registered design is all about the appearance of a product. It doesn't matter how it works or even if it does anything, it's just about what it looks like.
So if you can't get a patent, for example, because there's no invention, but the product looks different, that's to say it's a different design, you should get a registered design.
Absolutely, you should get a registered design in a case where you can't get a patent, and you should also get a registered design in a case where you can get a patent. It protects something different. Patents are for how it works, and the registered design is for what it looks like.
But it's not quite that simple, is it? There's a problem with protecting designs serving a technical function?
There is an exclusion, yes. So the law says that features of a design which are solely dictated by a technical function don't attract protection. But it's important to understand that is quite a narrow exclusion. Pretty much everything in this room has been designed. I mean, if you look around, we've got a lot of functional things, even these microphones, the microphone stands, they all do a job, but they've all been designed. Somebody has thought about what it's going to look like. And I think there's very few things you could point to and say there's been no design input into that, even if it's a functional tool for a functional job. There was actually a case in I think about 2018 about a colonoscopy device of all things.
A colonoscopy device, you're kidding.
Yeah, absolutely. There was a registered design case about it. Actually, it wasn't purely registered designs. They had some patents as well, but they did have a registered design. There was a standalone registered design argument. And interestingly, this point was made. It was said, but isn't that solely dictated by technical function? But there was some evidence that, in fact, yes, it had to work. But it also had to be acceptable. It had to look acceptable. Otherwise, it wouldn't sell. And that evidence was accepted, even for something like that, which is clearly a specialist tool for a specialist job that people buy primarily because it does the job well. It does still matter what it looks like. And so the registered designs in that case were found valid and infringed.
So how do you go about getting a registered design?
Okay, so procedurally it's fairly straightforward. We just have to file some images. So if we're protecting something like this mug, we'll take some pictures of it from the left, from the right, from the top, from the bottom. Show some good perspective views as well. Really just show images of the product, and that's all that needs to go in the application. The UK IPO will check that they're clear, so they're not on a sort of blurred or busy background. They'll check that they're consistent, so they all show the same product. And if it ticks those two boxes, pretty much they'll register the design. What they're not checking at the moment is whether it's a novel design, whether it's it's been done before. But the other thing that they're not checking, which is important to understand, they're not going to advise you on the best images to file. And the images you file, that is all that gets you your protection. They entirely dictate what protection you actually get. So it's really important to carefully consider what you put in and critically what you don't put in. Okay.
So, I mean, there have been cases, haven't there, where people haven't filed the right thing. For example, designers have lost out.
That's right. So probably one of the most talked about design infringement cases we've had in this country is about the Trunki, that little suitcase on wheels that you'll trip over if you go too near a child in an airport. The very, very successful product. It was about 20 years ago now, I think, that the designer Rob Law was on Dragon's Den. Theo Paphitis, I think, broke the sample and he left the den with no money. But that didn't stop it being a great success, of course. And I think 3 or 4 years later, Duncan Bannatyne actually admitted in an interview that that was the one that got away. So a little bit of an unusual admission, perhaps, from Duncan Bannatyne. But, without doubt, it was a very successful product commercially. Still is. See them all over the place. And there was a very well-known registered design infringement case, and Rob Law has talked extensively about it, because he actually, there was a copy or a competitor, depending on your point of view. He sued them for, among other things, registered design infringement, and it ended up going all the way to the Supreme Court, and he lost. The Trunki lost, and the alleged infringement was found not to be infringing the registered design.
So I think in that case, it was pretty clear that the competitor product was a copy, wasn't it? Although they had importantly made some changes. So why wasn't it caught by the registered design?
Yeah, I think there was pretty strong evidence of copying. It may even have been admitted. Certainly, it was done in response to the success of the Trunki. They had brought out this suitcase on wheels that looked a bit like an animal, and kids could pull it along in the airport. And I think Rob Law and perhaps many other designers, feeling solidarity with him, were kind of outraged. But when you get down into the sort of technical reasons, you can see the problems. And one of the issues that carries a lesson in this case is that the registered design images, they were grayscale renders generated from a CAD package. So they were grayscale, and that's important and quite a good idea. They didn't show any color because, of course, if you file for a red suitcase and someone comes out with a blue one, then that's a difference, isn't it? And that might be a difference that matters. So they had gone grayscale so that color didn't matter. But what I think they hadn't fully appreciated was that these grayscale renders did show contrast between colors. So, for example, in the Trunki registered designs, the wheels were clearly a different color from the body of the suitcase. You could see that. Even though it didn't show specific colors, it didn't show red and blue or whatever, it showed that some parts were different colors from other parts. And that was found to be a point of difference because the alleged infringement had these covers over the wheels. So actually you could hardly see the wheels at all. They were covered by these, I guess maybe you could call them mud guards, although I don't think they're really designed for muddy environments. But they had these covers over the wheels, which were the same colour as the entire rest of the body of the suitcase. So that did become a point of difference in the registered design infringement case, which the Trunki ended up losing. So the lesson there is, if what you want to protect is the shape and the shape alone, then filing line drawings rather than some sort of render that might show contrast is a good way of doing that.
So to get best scope, you would advise line drawings. Is there anything else that you can do to make sure that you get the broadest protection?
Yeah, so because all we can do is file images, the critical thing is obviously what are the images of. And one of the things you can do is actually file multiple designs. So to take an example of this slightly more interesting mug that we've got here, you might have a novelty mug like this, and obviously someone's put some thought into the shape. It kind of looks funky, if a little bit inconvenient to drink from. If you go this way around, you don't get the antlers in your eyes, at least. So someone's come up with this new and interesting shape for a mug, and in principle we could register this, couldn't we? We could take some images from all sides to show the shape. We could turn those into line drawings. Certainly we don't want a green-nosed version to escape or whatever, so we can protect the shape by showing it from all sides. But what if someone comes along and makes a mug which takes this sort of a reindeer appearance, but then has a different handle. Maybe they really put some design effort into the handle and make it look like a Santa hat or a elf or something, I don't know. Well, then we've got a mug which has copied this part, maybe even exactly, but there's a point of difference because the handle is different. And when you've got a point of difference, you may have a defense to a design infringement case. So what can we do to avoid that? Well, if we register just the part of the mug we want to protect and actually exclude the handle, say the handle doesn't matter, then we've got potentially a broader design. Because then it doesn't matter what an infringer does with the handle, whether they do a very similar handle or a slightly different handle or a very different handle. The handle is actually not part of the design at all. We say it's just to the mug, whatever the handle looks like. So you can do that. And say you've got a more complicated product. Suppose you've got something like a teapot, because that's got a spout and a lid and a handle and maybe some other bits as well. You could actually file a registered design that just includes the spout, a registered design that just includes the lid, a registered design that just includes the handle, and then maybe a couple of designs in combinations and one that shows it all together. So in any single registered design, less is more. The less you show, the wider the scope of protection you've got. So if you protect all those parts individually, and then somebody makes a copy but changes things, you might be able to find a registered design that they have copied almost exactly because the bits they've changed are in other parts. So that's a really good way of expanding your protection.
Sure. So would that add significantly to the cost of protection, though, because you're now filing a number of designs rather than just one to the product?
It does cost a little bit more, yes, but there's the good news is the discounts for filing a series of designs. So, you can file 3 or 4 designs. The price is still pretty reasonable. It's certainly not 3 or 4 times the price of filing a single design.
Sure. And presumably it needs to be a new product to get registration. How different does it need to be from previous designs to get registration?
Yeah, so it's got to be new, so we can't register things that have been known for years, and it's got to have what's called individual character as well. That's to say that on the informed user, it forms a different overall impression. Now, we could go on all day about what I mean by different overall impression, but yes, there's got to be more than, I suppose, a trivial change that nobody would even notice. Although the cases have tended to point to small changes being okay as long as they are noticeable to an informed user who's interested in the overall impression. I'm going around in circles, of course. That's inevitable from the way the law is written. But if you want something a bit more concrete, we've actually got a quiz on our website that that takes it's got pairs of images, and you can say, I think these look similar or you look different, and there is a right answer for every single one of them. At least there's the answer that the judges came to in the case, because they are all from real cases. So we'll put a link to it, I guess, and you can have a go at the quiz, see how many you get right. I mean, I say right, I really mean you agree with the judge.
Yeah, so if you would like to test yourself out as a High Court judge deciding design cases, then please do have a look at the link. So if you're already selling the product, are you too late to get a valid registration?
Well, not necessarily. So there is actually a short grace period. It lasts 12 months. So, if you've designed something, yesterday or last month, you started selling it, and now you're, watching this and thinking, well, I really should have got a registered design. Well, the good news is, yes, you still can. There are some disadvantages of using that grace period. I wouldn't necessarily recommend it as a matter of policy. Apart from anything else, it doesn't exist everywhere in the world. But we have got a 12-month grace period in the UK, Europe, USA, a few other important places, not everywhere, but a few places. And if you need it, if you have launched the product already and now you're thinking I should get a registered design, then it is there for you to use.
Okay, and so if you've got a lot of products, some of them might do really well and some of them might not do so well. Often you don't really know how well something will sell until you've tried it. So you could start selling the products, see which ones fly, and then get registered designs on the ones that are worth it.
You could do, yeah, and there are some industries that do often take that sort of try it and see approach. We'll launch 10 products, 8 of them will probably fail, but we don't know which ones. So, and the 2 that succeed will more than make up for it. In some businesses, that's a strategy, and in fact, it's a strategy that sometimes works really, really well for people. And so I guess the grace period could be useful there, yes. What I would say is more useful, though, is the fact that actually, because of those discounts on the series designs, you can file on all 10. It costs much less to do them all at once as a series, and then you've got the protection from day 0, if you like, on whichever ones are those that succeed. The ones that don't succeed, you may, in 5 years when the renewal fee comes up, you may say, I'm not going to pay the renewal fee on 8 out of 10 of them, but you've got that protection for all of them in that period of time.
So really take the discount and file as soon as you can then?
Yes, that would be my advice in general. And yeah, I mean, file as soon as possible. You never know what your competitors are going to do next week. I guess there are a couple of caveats to that. The first is that once you file for a registered design, if you don't ask for it to be deferred, that costs a little bit extra. So that is an option. But if you don't ask for it to be deferred, it can publish pretty quickly in the UK within a matter of weeks, or even days sometimes. So you need to be prepared that will happen. Your design will be published and anyone will be able to see it. The particular implication of that, if you're thinking about getting a patent as well, which of course is a very good idea if there's something patentable about your product, normally recommend you do the patent first, so that in filing your design you don't pre-disclose the idea and scupper your chances on the patent. The other point I would make is that we would normally say, well, file a registered design when you're pretty sure what the final version of the product is going to look like. Of course, in product development, it's very common to tweak things, change the way it looks, make all sorts of changes. And I think, there's always a little bit of, when is the right time? There's no absolute right answer to this, but waiting until that you are going to sell that product that looks exactly like that pretty much is probably a good idea.
There was another high-profile case involving the iPad design, wasn't there, that illustrates this?
Yes, there was. So if you remember back to, say, 2009, the iPad didn't exist in those days. It was launched in 2010, and some people like them, some people hate them, but it really was a brand new thing, wasn't it? No one really had a tablet computer like that, certainly on the mass market, before Apple came out with the iPad. And it's been a very successful product, launched, as I said, in 2010. The interesting thing about it was that they'd actually filed a registered design for a tablet computer back in 2004, a whole 6 years before. So quite a gap. Presumably it took them quite a while to fit all that stuff in one box. And of course, when they did launch the iPad, it wasn't long before competitors came out with their touchscreen tablet computers. And in particular, Apple sued Samsung for registered design infringement. Apple complained very publicly that Samsung had copied the iPad. And who knows, there may have been some truth in that. But as far as the registered design case was concerned, that wasn't the question before the court. The court had to compare the registered design images that Apple had filed in 2004 with the Samsung product. And I think the judge in that case, in the Court of Appeals, Sir Robin Jacob, actually said this case has to be decided as if the iPad had never existed. It doesn't matter what the iPad looks like, because the comparison is all about the registered design images and the Samsung product. And those registered design images were filed 6 years before the iPad was launched. So there were, I think, quite a few differences. The judge said, well, I've had a look at it. I think there are some differences from the iPad, but it doesn't matter. It doesn't matter what the iPad looks like. I've got to look at the registered design images and Samsung's product. So who knows what the result would have been if it had been a comparison between Apple's product, very successful product, and the Samsung product. But it wasn't. That wasn't the test. The test was between the 2004 design images and Samsung's product. And on that comparison, it was found to look different. So Samsung walked away the successful defendant in that case.
So you might say that Samsung got away with one there. So once you've got the design protected, what does it cover? Does it need to be an exact copy to infringe?
No, it doesn't need to be an exact copy. You don't strictly need to prove copying at all, actually. But it doesn't have to be exactly the same as the registered design. It's the same or the same overall impression on the informed user is what the law tells us we have to look at in a comparison. And the only further clue that we're given by the statute is that in assessing whether it produces the same overall impression, we have to take into consideration the degree of freedom on the designer. So we've got, I guess, two people to get inside the heads of: the informed user and the designer. And there's been, probably close to books written on the characteristics of the informed user. Over the years, judges have said an awful lot about them, in particular what they're not. They're not in the business. They're not a wholesale buyer of this type of product. They're certainly not a designer themselves. But on the other hand, they're probably a lot more informed and a lot more careful and observant than probably the vast majority of real people who buy goods. I think a fussy customer, if you want to sum it up in 2 words, might not be too far off.
I can't imagine who that might be. I think you might need those books.
Yes.
So then we have to consider some constraints on the designer.
Yes. So we got our informed user, who, as I say, is the kind of fussy customer. The law tells us we've got to look at the constraints on the designer, and very often that has a lot to do with how the product works. So to take an example from a case a few years ago, if the case is about a shoe, then it's got to fit on the foot. You've got to be able to walk in it. It sort of goes without saying that most products need to do a job, so there's some constraint there. But when you go beyond that constraint, there are smart shoes, there are funky shoes, there are those enormous shoes that clowns wear. There are all kinds of different shoes, so there is some scope, once you've made the product work, for designers to exercise some of their design skill and come up with a product that looks different. So we have to look at the constraints on the designer. Obviously, if the designer is highly constrained and there's really not much they can change once they've made the product work, then smaller differences are going to have a greater impact on the overall impression. But where the designer could do, anything in the world and chose to do exactly the same thing as the previous design, that may be taken to not have much or impact on the overall impression there. So that's where the constraints come in. We also have to look at what's called the design corpus, i.e. the whole sort of body of prior designs in that particular area. So all the shoes, all the mugs, whatever it may be. And the reason that comes into play is for similar reasons, actually, as the constraints on the designer. If the designer does something, really new and radical, makes something that's nothing like anything that's gone before, then that's going to have a really big impact on the informed user. They're going to sort of see that radical new design, and then a small change to the radical new design is kind of potentially going to go unnoticed, because the one big thing that was new about the design still stands out and sort of covers up those smaller differences, if you like.
Sure.
Whereas if the designer, as is very often the case, is really making more modest changes to that body of prior art that's gone before, tweaking something here, tweaking something there, there still may be a valid design, but because I think the phrase from the case law is surrounded by kindred prior art, the impact of any changes is going to be greater. And so, an alleged infringement which changes it slightly would have a greater impact on an informed user, and they would see it as a difference. So what that means in practice is if you've got, a radical new design, you'll get some hopefully pretty broad protection. Whereas if your design is really just incremental, then the protection will be narrower. And if you think about it, that seems fair, doesn't it?
Sure. So if you decide not to register and then someone copies you, is there anything that you can do at all about that?
Well, if you're outside the grace period, of course, you can't get a valid registration at that stage. But you have got some rights that are unregistered. So there are such things as unregistered designs. And actually, they can be really powerful. One of the lesser known aspects of the Trunki case is that Trunki actually ran a case on unregistered designs as well, and copyright, I think, and they won some of those points. So although they had this high-profile loss in the Supreme Court on registered designs, they did have some success at first instance on unregistered designs. But I think the problem with unregistered designs, and I'm guessing the reason that Rob Law fought so hard on his registered rights, is that unregistered designs don't last very long. There's a couple of different kinds of them. One of them lasts 3 years, one of them lasts 5 years to the end of the calendar year before people start being able to take licenses under them at least. Whereas a registered design can last up to 25 years if you keep renewing it. So although unregistered designs, well worth considering, we always consider them, whether or not you've got registered designs, if someone comes to us with an infringement problem. The registered designs last much longer, and so commercially for a product that lasts, they're very, very valuable.
In summary then, Freddie, you can protect parts of a product with registered designs in the UK and Europe to maximise your protection. You can still potentially file after you've disclosed using the 1 year grace period, certainly in the UK. Registration is very fast, possibly within a week of filing, giving you enforceable rights. It's cheaper than patenting, and you don't need a technical contribution, simply a new appearance. So, would you say that registered designs can be more powerful than patents?
Well, there's no right answer to that question, is there? And I certainly, if someone comes to us with a new idea for an invention, something that works in a new way, it's got some good technical advantages, patents are the thing. Patents, really are designed to cover those new technical inventions, and you get patent box tax relief as well. So I wouldn't normally encourage people. I wouldn't say, forget patents, just get registered designs. Of course I wouldn't, I'm a patent attorney. But no, patents are really, really powerful. But what I would say is, don't forget registered designs. And whether or not you're doing a patent, you might have a technical product, in which case we'd certainly, advise patent protection if there's something that can be got. But whether or not you're doing that, registered designs protect the appearance of a product, and they can be really, really valuable in their own right. Going back to that colonoscope case, I think it's Ark and Cantel, if you want to look it up. That was a really interesting case, actually. They had 2 patents. They had a registered design. I think there was possibly some unregistered rights that were argued as well. And actually, the claimant won. I think both patents were found valid and infringed, and the registered design was valid and infringed as well. But when they filed that claim, were they sure they were going to win on the patents? Well, of course not. Who knows what prior art search the defendants might have done. It's never a done deal. They might have found some obscure disclosure from 30 years ago that blew the patent out the water. In the end, that didn't happen, but they were able to run their 2 patents and the registered design, which has a completely different legal test that protects the appearance of a product. So, it really was giving them another bite at the cherry. And I think that can be a real power of registered designs, that's illustrated there. So don't forget them.
Thank you, Freddie, for joining me today. I hope that you've enjoyed listening to Figure 1, an IP conversation brought to you by Albright IP, and I look forward to you joining us next time. Thank you.